I'm Chantal Bernier. I lead the privacy and cybersecurity law practice at a firm called Dentons, and that's after 27 years. I know some of you must think, 27 years, I didn't even born. And yet I spent 27 years in the government of Canada as a senior official, my last stint as leading the Office of the Privacy Commissioner of Canada. So I assume that that's why Alison extended an invitation to me. And the reason that I accepted it, in spite of the fact that my assistant said, yes, you're free, but you're free because it's a Sunday. I said, I'm going to learn something there. And I can tell you, it's already accomplished. So thank you for the invitation, Alison. We have a very interesting panel, and I can tell you for having read their papers, very interesting, relevant panel. We have Richard Yanda, who is a professor associate at the School of Environment at the University of McGill. We have Catherine Sandberg, who is a professor of law at NYU. We have Ignacio Cognoni, who is a assistant professor at the Faculty of Law at McGill University, and Claudia, who is a professor, an associate professor at Northeastern University. She teaches where she does law and political science. And we have Karen Altis, who was the moderator already in panel 1, and we're very lucky to have her again. When I say to you that the papers are so relevant, I can tell you that I was reading them and seeing my cases, because I'm the practitioner here, right? They're the academics, and I was seeing my cases reflected. For example, just to really drive the point of how topical these subjects are, Richard Yanda, in fact, in his paper on governance of algorithms and AI, mentions smart cities, which are totally the convergence of all that. And one of my biggest files, which I'm allowed to talk about because my client has relieved me of this kind of privilege, they actually said to everyone that I was their privacy counsel, is Waterfront Toronto negotiating with Sidewalk Labs the creation of the first, if it happens, smart neighborhood in Canada. And all the issues you are raising in this paper, Richard, really just are the issues that are coming up in our negotiations. And then after that, I moved to Catherine and Ignacio's paper, where I saw the issue of transparency of algorithms, which is what my clients are dealing with right now. All of my clients that have automated decision making, the vast majority of them, for example, optimization of data platforms on the internet, they use algorithms, and they're worldwide. Being worldwide, they are subject to the General Data Protection Regulation, which came into force May 25th. And the General Data Protection Regulation, GDPR, actually provides that algorithms, it doesn't say it that way, but must be transparent. What it does say is data subjects whose personal information will come under automated decision making need to be told that there's automated decision making, and the logic models, whatever that means, and I hope you will help us, the logic models must be transparent. And the whole issue of transparency of algorithms is very much alive. In fact, go to the Government of Canada, Treasury Board of Canada website, and you're going to find guidelines on bias and transparency of algorithms. So again, I saw Ignacio and Catherine's paper completely evoking that, and they take us much further than mere privacy, but definitely very topical. And then I was sharing with Claudia at lunch that her paper, well, I have clients struggling with that as well. I have clients that produce devices that use AI for medical purposes. And I have clients that use those devices to provide medical services. So, for example, radiologists, and well, like, if you have two radiologists looking at an X-ray, well, you can have one radiologist looking at an X-ray and the other one being AI. So your whole article is also extremely relevant. So I really ground this panel into real life because it truly is reflecting, from what I can see, issues that are truly calling for an answer right now. So we're going to go from macro to micro, and so we're going to start with Richard, then Catherine, Ignacio, and then Claude.
Dans ces couloirs, on présume toujours un niveau de bilinguisme passif. Et à cause de ça, je présume, la revue de droit m'a demandé de faire le texte en français et de me présenter en français aujourd'hui. However, we discovered through this morning that we had a number of guests here and friends participating for whom we couldn't necessarily presume that giving the presentation in French would make sense. So I have my slides in French, but I'll speak to them in English, and I hope that that will produce some kind of odd McGill style. As was mentioned in introducing this paper, it is a somewhat macro paper, and I must say that I will be presenting ideas at probably too high a level of abstraction, but I hope that by touching on sort of high-level themes in our paper, that might generate conversation. When I spoke with my co-authors about the paper on Friday, one of whom is here, Juan Pinto, who are, of course, much more informed than I am and trying to teach their old dog professors some new tricks and learning about this area. They told me, keep it simple, just express why we're interested in the problem of solving collective action issues with access to the new technologies that are available to us, notably artificial intelligence, digitization, and blockchain. Then express the fact that we have concerns nonetheless about these technologies, about how to govern them legitimately, and forms of dystopia to which they could give rise, and then end with some suggestions about solutions and ways forward. That was what I was supposed to present. But as we spoke on Friday, we came across something that I couldn't resist exploring with you now, which is that we're in aporia. That is that we actually may face dead ends in some of these investigations. We may not have a simple straight line trajectory from problem to solution. And so I would actually like to present the aporia to you, despite the fact that my students told me, don't. But that in itself is an aporia, and maybe I'm reflecting, therefore, the kind of problem we're facing. So let me start with one dimension of aporia, which I think is what brought us, at least my co-authors, to the investigation of real-time signaling of impact and social scoring. I have a few quotations from the latest report of the Intergovernmental Panel on Climate Change issued just a few days ago that highlight the scope of the collective action problem that we're facing on climate. And it is, of course, only one dimension of what we could now call the Anthropocene that we're in. So we're told that we should avoid increasing temperature on the planet by 1.5 degrees Celsius at risk of extreme changes to the climate and significant loss of ecosystems. And the policy implication of this that the Intergovernmental Panel on Climate Change has put forward precisely for policymakers is a rather remarkable collective action problem we've got to solve. How to diminish by 45% the greenhouse gas emissions that we're now making by 2030, and how to get them to zero by 2050. And to put this even in sharper perspective, one of the most dramatic statements that the Intergovernmental Panel on Climate Change has been repeating, and that I don't think has actually penetrated public consciousness very well, is that the emissions that we're generating now already will persist, they say, for centuries, if not to say millennia, at current levels. So this is not a problem that we can turn on and turn off as we address the results of our collective action. It's one that we will not only give to the next generation or to a few generations, it's one that we're bequeathing to the foreseeable future, at least on a human scale. So if this is one dead end that we face now, that we're passing through planetary boundaries with our collective action, what is the relevance of the kinds of technologies we've been talking about today to addressing this problem? Well, what we had assumed in some of the work that the research team that I've been involved with has been doing is that perhaps we could learn how to signal to each of us the collective impacts that we're generating. If we could signal them in real time, could we produce some sort of platform for behavioral change? We've been conducting experiments on this, and with some promising results. And indeed, we discovered last summer, I believe, that something very parallel was now taking place in China. The Ant Forest project that's been set up by Ant Financial as a subsidiary of Alibaba, where now some 300 million users are engaged in tracking their environmental impacts. But as our paper discusses, there are also some very problematic implications of the ability to gather all of this data, and that leads us to a second kind of apparatic problem. I'll get at it quickly this way, drawing on the work of some of you I'm sure have read, of Yuval Noah Harari, who's been writing on the problem of what he calls Homo Deus. Harari notes that in his judgment, the faith in technological solutions is actually part of the problem of climate change, in that those who are now sort of denying the need to work quickly on the problem are putting their faith in the development of solutions into the future, solutions that they think not only might exist, but we must assume they will exist. And the feature to which he draws, I think, more explicit attention than I've seen done before is that he thinks what he calls a superior caste, those controlling capital and resources, are simply assuming that they will be able to buy their way out of the problem if and when it arises. He calls this the idea of a high-tech Noah's Ark. The photograph, the image I've got here is from a film that already depicted that idea, the film Elysium, that some of you may have seen. And that he goes so far as to say that this idea itself is one of the most serious dangers that is facing us and facing ecosystem. How does that connect to the problem of governing algorithms and governing artificial intelligence? Again, drawing on Harari, he claims that artificial intelligence is in fact, unlike previous technologies, one that favors centralization of control because the gathering of data on a large scale improves the machine learning that comes from those systems, and to be able to fix the points of entry into the system actually favors, he says, the outcomes that are being sought. So I summarize all of this, and a large part of our paper is saying that there's a second dead end that we're facing as I structure this aporia, that the centralization of control over technology guided by artificial intelligence in the hands of a superior caste is one that we are now starting to see happen. Let me then conclude in this way. Aporia means literally no pores, no passages, no way through. And I think that one of the things we can ask ourselves is, how can we live with such a circumstance, accepting that it is the structure of our contemporary problem, but start to map ways through it, ways, so to speak, to deconstruct it. So that's what I'll just allude to very quickly in conclusion. The first way through, I think, I draw on my colleague Rod MacDonald, who made this interesting observation that every time you look at shifts in regulatory structures, shifts in governance, you actually find that the sum total of all the activity remains something like a constant. So when you think that things centralize in one direction, you're not paying attention to how, in fact, they're decentralizing in other directions and so on. But if we can actually start to map not just the tendencies in one way, but the tendencies in the opposite ways, that we'll start to find trajectories, perhaps find trajectories out. We already had allusion earlier today to the work of Eleanor Ostrom, which I think is a very important part of how to think about the aporia we're in. Modes of polycentric governance that connect not only the centralized bits together, but actually can interact with the decentralized modes that we started to talk about in the last session. I do think that we can explore real-time signaling of impacts. Again, we had allusion to that in the prior session, that the lawyers themselves are starting to work in this fashion, and that we may learn how to do it through technologies like blockchain. And finally, I do think that we need a new setting in which to imagine why the interaction with all of this technology is something that attracts us, something we want, something we seek, not just something we engage in for the sake of avoiding difficulty. And I think that the emancipation from the consumption that attracts us and revering what we've been given is something I'm learning from students, and something that I think might orient us all. So those are a few very high-level general thoughts. I hope they'll lead to further discussion.
Thank you, Richard. I must say I made the mistake of reading your paper before going to bed. And the Chinese example, to me, as a privacy lawyer, really gave me nightmares. But we'll talk about that in a moment. The other thing I want to say, as Catherine and Ignacio make their way, is that I've heard the word polycentric used twice today, and I think we should put a little TM on it, because Dentons, we thought we had invented that word by putting ourselves forward as the polycentric law firm. And now I'm thinking, oh darn, do we have to invent another word like supercalidocious to stand out? Anyway, but thank you. Perhaps you're copying us. I'll just take it that way. I heard about it, thought it was so clever that you would use it as well. So, Catherine, over to you.
Eleanor Ostrom did win a Nobel Prize. So,
Yeah,
you know.
Well, there you are.
Good company. Okay, well, I'm going to talk about something that's on a much more sort of nitty-gritty level, especially because at this point it's still very much work in progress. And this is a project I'm doing with Ignacio, who is right over there. The way this is going to work is that I'll give the presentation and Ignacio will answer all of your questions. And the other thing I have to say, disclaimer, for Ignacio is that I put these slides together kind of last night and this morning, and he has not seen them, nor has he approved them. So we'll see how it goes. All right, so our project is motivated by this question that of algorithms, and by which we sort of mean, machine learning algorithms, AI type algorithms, and questions about secrecy, transparency, and so forth. And I've kind of been getting at this point from a couple different angles in my own work. I've looked at explanation and these questions about how, it's so hard to explain what algorithms are doing when you're using deep learning, neural nets, and so forth. But one of the things that I noticed as thinking about that is that despite this idea that, so many algorithms are so hard to explain, in fact, what is really going on in many, many cases is not that it's so hard to explain, or at least not only that it's so hard to explain, but also that there's all this secrecy. And so there are various arguments that can be made about the secrecy, why it's necessary, why it's not, and one of them, which is the one that Ignacio and I are interested in thinking about in this paper, is this idea that you can't disclose the algorithm because then people will game the system. And we started from a point of kind of skepticism about that. And so what we're trying to do in this project is to use a kind of line econ approach to drill down on it and say, when is disclosure going to allow someone to game the system? And when is disclosure a bad policy or a dangerous policy? Rather than allowing it to be just kind of this blanket thing like, you disclose and people will game the system. So to just kind of provide a little bit of language and overview of what I'm going to be talking about here, here's a very simplistic anatomy of a sum predictive algorithm for making some decision, right? And I'm kind of thinking of a machine learning algorithm here. So I start with a bunch of data, features is often the term used, and I use an optimization method to come up with a predictive model. And my predictive model is predicting some variable that is chosen by the person who's doing making the model. That's sometimes could be called a label, a class, a target, various things it could be called. And that label or that class or that target is the thing that's going to be the input into the decision that I end up making. But this label and class and target is usually only a proxy for the thing I actually care about. That's my real goal, or in economic speak, the type that I'm really trying to figure out. And so the thing that's going on is I have this model, I get a proxy, I make an actual decision. But if I could really figure out my goal or my type, I'd make a better decision or the best decision. So this is kind of the framework we have in mind. Now, to give you just an example of what this might mean in a particular example, imagine a recidivism risk assessment algorithm, right? So you start with a bunch of data, so things like prior arrests, is the person unemployed, are they a gang member, et cetera, et cetera, et cetera. You put all this data in, and you come out with a predictive model. And what most of these models actually predict is the likelihood that a person will be rearrested. Okay, so likelihood of rearrest. And then what I might do, of course, it's never exactly this automatic. There's always a human in the loop, but just as an explanation, what I might do is, I might say, if there's a high likelihood of rearrest, detain this person until trial. If not, let them go. Okay, so that's the kind of idea. Now, maybe what I really care about is if I let this person go, are they going to commit a violent crime? Right? Maybe that's what I really care about. So if I knew that, what I would do is I would detain people if they're going to commit a violent crime, and otherwise I would release them. But I don't know that, I don't have the data to predict it, so I'm predicting rearrest. So in these cases, we have some sort of data, a predictive model, and it's predicting something that is really a proxy for the thing I actually care about. And that's kind of the point that we're going to focus on in our thinking so far. Okay, so how am I supposed to evaluate whether or not I've got a good proxy? So I'm going to show you a couple. Now my presentation is full of these tables, so I'm going to try to help explain what I'm talking about here. So in the top one, I have on the left-hand side, I've got two kinds of proxies. And I'm going to really simplify this and say my proxy is either just positive or negative. Like this person is likely to reoffend or not likely to reoffend. Of course, that's an oversimplification. like a real type, like what is this person really like, a good type, and a bad type, okay? And when I do this, I can make various sorts of correct and incorrect predictions. So I might have a positive prediction, and it turns out that prediction's right, that's a true positive. I end up detaining the violent recidivist, that's good. But I might predict a person is risky, and in fact, I end up with a false positive and end up detaining the non-recidivist. Or I might think I might make a mistake, and I might think, oh, this person is not likely to reoffend, but I might be wrong. So I might end up with a false negative where I release the recidivist, or I might end up with a true negative where I just release the non-recidivist. Okay, so false positives, false negatives, true positives, and true negatives. Okay, so, oh no, my little emoticons didn't show up. Oh no. Okay, some of them did, but not all of them. From a social perspective, how do I think about what I'm getting out here, right? So let's also totally oversimplify and say I'm going to have mistakes. My mistakes are either false positives or false negatives. And I might be in a situation where I have a high number of false positives are high or low, or a high or low number of false negatives, right? So if my algorithm produces a high number of false positives and a high number of false negatives, that's not good, right? That's a bad algorithm. It's making lots and lots of mistakes, so I'm unhappy. On the other hand, if it produces a low number of false positives and a low number of false negatives, I'm letting out the right people, I'm keeping in the right people, then I'm happy. So that's good. But of course, very often I have something on these sidelines. So I've got a low number of false positives and a high number of false negatives, right? So I'm actually keeping it, I'm making not very many mistakes about the people that I think are going to be recidivists, but I'm making a lot of mistakes about the people that I think are not going to be recidivists. So people I keep in are all pretty much recidivists, but then I let out a bunch of people who aren't recidivists. That's not great. Or I do the opposite way, like, you know, I have a high false positive and a low number of false negatives. Now, in both of those cases, I've got some trade-offs going on. So I might not be sure of what I think. So I could have a great algorithm or a really bad algorithm, or I could have more often something in the middle. All right, so that's kind of an overall situation. Now, oh no, 2 minutes? Oh dear, okay. Well, basically the problem that I confront when it comes to disclosure is that I have this gaming problem, which has to do with the decision subjects, but I've also got a big principal agent problem, often, which is the person who's making up this algorithm does not have the same goals as society should have, society has. The person who's making up the algorithm might be, everybody's happy if it's a great algorithm with low false positives and low false negatives. That's great. Society's happy, the person is making. And everybody thinks it's useless if it's got a high number of false positives and a high number of false negatives. But from a social point of view, I might think, okay, if it's a high number of false positives, a low number of false positives, like not very many people kept in jail who shouldn't be, but a relatively high number of false negatives, oh, I let out a bunch of people who went on to commit crimes, well, hey, that's like that 9 people free rather than 1 person jailed, you know, like presumption of innocence. Maybe from a social point of view, I think this is okay because I want to err on the side of justice. And on the other hand, if I do the opposite thing, I might say, oh, this is really bad. I'm keeping a whole bunch of people in jail who didn't need to be, get a better proxy. But the decision maker, in a situation, for example, where the media only reports things when somebody who I release commits a crime, is going to think, oh, all right, I really don't like it when the error rate's high on both sides. Okay, that's okay. We're both agreeing on that. We're all happy when the error rate's low on both sides. But whoops, here, if I let some recidivists out, I get a lot of bad press, so I'm not going to like this algorithm, even though maybe society would have been okay with it, right? So these are principal agent problems, and there's lots of reasons why we might have these kind of principal agent problems. Well, then you might say, okay, great, but why don't we just pick this one, the one where we always have a low false positive and always have a low false negative. Everybody's happy, the decision maker's happy, society's happy, it's all great. Well, we might do that, But we might not, because it might be more expensive to come up with a better proxy. We might not have the data, we might have to do more work to come up with a better proxy. And in fact, not only that, but the cost might be something that society is willing to bear, but something that the decision maker is not willing to bear, for whatever reason. So we end up with these kind of principal agent problems. So it might be that the social optimum is we're going to decrease false positives, or we're going to decrease false negatives, but the decision maker's private benefits is no, I'm going to do something else. Okay? So this is why we want to have disclosure. And there's all kinds of other things we can talk about why I want to have disclosure, but since I'm out of time, I won't. So that's one side of it. The other side of it is, what about this socially undesirable gaming? Like, is it something that can always happen? Well, what is socially undesirable gaming? It means I had a negative proxy and I somehow managed to turn it positive, but I stay bad. I'm still a bad person, but I look good, right? I do that by investing some money. When can I do that? Well, when it's relatively cheap to do it. I'm not going to be able to do it if it's expensive or if the proxy is some immutable characteristic. So it has to be easily changed. And also I have to be able to change the proxy while staying bad. So if changing the proxy means I become a good person, then I'm not gaming. I'm complying. That's called compliance, right? Okay, so gaming's not likely if it's really hard to change your proxy, or if in order to change the proxy, you're pretty much likely to be compliant. So in the end, disclosure might or might not produce gaming, because it might be too expensive to game. It might be that if I attempt to game, I actually comply. So there's a limited place where disclosure is going to actually produce bad gaming that we're going to be worried about. And I'm actually thinking maybe I'll just stop with that. What do you think? Should I add something to that? I think I'll stop with that. I have more. Because I think that's the main point.
Thank you.
So going back to the General Data Protection Regulation, I think this is a fabulous illustration of why the European lawmakers chose to put in the General Data Protection Regulation that no decision that has an impact on the rights of a person can be made by AI only. It has to be subject to human input. And I had a discussion, I think last week or the week before, as to whether indeed we could ever reach a time when equity would come within the capacity of AI. I think, Catherine, you've really shown all the trappings of applying AI to a decision that has impact, that has legal impact. So thank you for that. And I assume, so Ignacio is not presenting now?
I am not saying anything.
You're not saying anything? He's just going to now. So we're going to move to Claudia, if you could give us your presentation.
Great, thank you. And I want to thank Chantal for coming up with the, this kind of organization of the panel that flows very nicely. And thanks to my co-panelists for really teeing up the issues. And now I can solve all the problems. So my question is, how should we govern professional advice given by AI? And so, it's really good to bring up the human component there, because I don't actually think that AI will completely replace human professionals yet. And so I'll just operate under the assumption that there will be some human involved, at least for the time being. And as you already mentioned, so there's the sort of the doctors using I like to use the medical example because I think we have very strong intuitions in the medical advice field, and I think that bringing out those intuitions is really helpful. At the same time, though, I want to talk across professions, because I think there's some other traps that we might fall into by being kind of sector specific. But so using the doctor example again, so there's doctors using AI in kind of the sort of professional capacity. So you might think about those as sort of professional use algorithms, and then there's this other universe of patient-facing, which we now think about mainly as consumer electronics, right? So the kind of Fitbit universe that you can expand into all kinds of uses. I think for purposes of right now, I want to focus on the kind of the professional side of things. So starting with a fairly high level of abstraction there, I want to look at what framework we have currently to govern professional advice giving and why we have that, right? So if you again think about the medical field, technical innovation in the medical field is occurring in a densely regulated space that's densely regulated for a reason. And so this also came out in the other panels this morning. So don't forget the humans, right? So you're trying to actually make sure that your doctor, your lawyer, your accountant gives good advice to a client for whom this has real world consequences, be it financial or, again, this is why I think the healthcare context is so useful. This is actually affecting somebody's health. And so, one thread I want to kind of pull on that came out earlier was, is this something completely new and something completely different, and do we need a completely new regulatory framework for this, or is this something that works within a structure that we've already established? And so my goal in this paper is kind of to bring out what this legal framework is that we have that ensures professionals give good advice. So you might start with, what are our regulatory options? And so, again, medical field, some people in the health law literature say, well, we should just go with, FDA regulation, right? So we should give all of these things to the FDA, and then they can decide. Well, that immediately falls into, first, the trap that only works in the medical context. So what do we do with other professions and other professionals? The other problem is what I mentioned earlier about the consumer product side of it. So that falls outside of the regulatory scope of FDA regulation, and so we're kind of stuck again. We could also think about this is also something that's already been proposed. It's sort of a separate agency for AI, sort of like an FDA for AI, but not just for the medical context. What I'm proposing is to go with the current mix that we have, this regulatory framework of professional advice giving that really puts the professional-client relationship at the center. And so there we see, again, focusing the technology and the regulatory framework around this human interaction that we've had that kind of forms the basis of why we have professional advice in the first place, which is an asymmetry of knowledge between a professional and a client, where the professional has knowledge that the client lacks, but they really need to make really important decisions. So if that is our goal, then I think we might just start with the current regulatory framework that is sort of a mix of common law and statutes, and mostly state level rather than federal, that has a couple of components. Most importantly, I would say professional licensing, professionals' fiduciary duties to their clients, professional malpractice liability, and professional ethics. And so if we start with this framework, we can, I think, start to assess whether what we have now works or whether it needs tweaking. And so I'm not saying that it's all perfect the way it is now. Quite the contrary, this is a very good opportunity for us to reassess what we currently have and whether it works. And so, again, take the medical context. So there's a lot of debate over informed consent. And people are saying, oh, informed consent is terrible, and it totally doesn't work, and, just forget informed consent. And then the question is, well, why do they say that? Is it because the idea of informed consent is bad? So you want to think about the doctor-patient relationship. We had a very sort of parochial model in the beginning, where the doctor just did whatever the medical profession decided what was the right thing to do. And then we shifted to a much more patient-focused autonomy model, where we said, well, actually, this is, the final decision about what we do has to be with the patient, because that's, it's about them. And we have that across professions. So if we take that seriously, we need something like informed consent. All right, fine. Then empirically, we find out that informed consent doesn't really work the way that we want it to work. So does that mean informed consent is a terrible idea? No, it just doesn't work the way we want it to work. So what's the fix? We make it work the way we want it to work. And so if we now try to incorporate something like AI into that framework, that's actually a really good opportunity to reassess our currently existing structures. And I think, once we start focusing on the social interaction, we see this is actually something that Jack Balkin has recently said. He says, the proper focus when you assess the role of algorithms should be on the question of how algorithms, is a quote, how the algorithms are engaged in reproducing and giving effect to particular social relations between human beings. These are social relations that produce and reproduce justice and injustice, power and powerlessness. These are all themes that have already come out over the last panels. So power and powerlessness, superior status and subordination. The robots, AI agents, and algorithms are the devices through which these social relationships are produced and through which particular forms of power are processed and transformed. And so when we start inserting AI into these existing human-to-human relations, I would suggest we start with the values underlying those social relations that we've already developed or that we've already incorporated into a regulatory framework. And so let's start with that before we throw out everything. And so in the world of in a world of kind of move fast and break things, as we were saying earlier. So maybe the solution is kind of to move slower and think about the existing structures and make them better and tweak them along the way. And most importantly, remember the human element kind of in the middle of that. And I'll just end on that.
I would like to publicly denounce Tim Cook for having plagiarized Claudia, because this is what he said in his speech. Okay, he gave it before Claudia to say her speech, but I know he copied her. So this is Tim Cook speaking at the International Conference of Data Privacy Commissioners in October, where he just skewered his competitors, just really, anyway, he was pro privacy and everything, but this is what he just said that I think really echoes what you just said, Claudia. Platforms and algorithms that promise to improve our lives can actually magnify our worst human tendencies. And so that has to be taken into account. Machine learning is done initially by humans. Hence, all the inaccuracies that Catherine and Ignacio, you have brought up in your reasoning, the danger of entrenching bias rather than removing bias by feeding the machine the data elements, as Catherine was showing so well on her diagram, that actually would lead to a false result. And a false result that is compounded by the illusion of scientific rigor. So we really do need to take that into account. I'm going to ask Karen to do her commentary.
Thank you. 2 or 3 quick comments depending on when I'm restrained, and I'm going to make an effort to speak far more slowly than I did the first time around, seeing as how it's the afternoon. With regard to Richard's presentation, as he was presenting, and of course quoting Harari as he does in his paper, I was praying that he wouldn't quote this direct saying, because this was my comment, and he didn't. So I wanted to bring this out. Harari said, we should fear AI because it will obey its human masters. So he grasped the distinction, not because it won't, but because it will obey its human masters, while allowing them to evade responsibility. So the first component is sort of the opposite of our space odyssey, oh, I'm sorry, Dave, I cannot do this right now, model, but rather these AI masters that, as has been noticed, have baked in bias, right? Racist bias, to discriminate, for lack of a better word, potentially against a female candidate, or when people take your call at a hotline or at a bank helpline, and someone might have an accent, right? You see that those employees who are immigrants or first-generation Canadians or Americans may be disciplined more frequently or not promoted because the algorithm has this baked-in bias against accents or facial features or so on. In medicine, and I wanted to comment further on Claudia's excellent paper, but time doesn't permit. It's being used in pediatrics in terms of recognition of facial features. And I have written about this in the context of genetics, but there can be a predisposition to discount certain disorders in certain cultural communities because it's simply sort of skimmed over and attributed to the culture as opposed to actually looking at those facial features because the algorithm was built with a certain very westernized model in mind. So in the end, what's important to retain is that machine learning will be about decision making, right? It's about decision making. So you need oversight. Now you've probably heard about FACT, and I'm not referring to the chocolate fountain that was there, but rather fairness, accountability, transparency. And there's a bit of a tension, as was referred to in the paper, between sort of allowing that transparency, allowing that oversight, and giving away, as Catherine mentioned, the trade secrets. And from the very excellent paper in the first panel, Professor Mann, I was thinking about how tax audits are made. And apparently, and I don't know anything past this, but I understand from it there's something called DIF, and the IRS essentially has a model, a crypto model, for selecting who will be audited. Now, obviously, they can't disclose what the model is, otherwise it will be, as you so eloquently said, gained. But there is a possibility for transparency in terms of one being audited if one alleges discrimination. So I wonder if that's, since we're at McGill, sort of a piece de solution, looking at how these models were employed in a different context, where yes, you cannot game the system, so you cannot disclose, but there are ways of ensuring some transparency. Otherwise, and rejoining Claudia's excellent paper, you end up with black box medicine, this sort of idea that the paradox that the physician, in order to avoid liability, needs to understand, right, what they're doing and is held to a certain level, but they cannot understand because they cannot be involved at this technical level of putting together the algorithm. So for regulation, that brings me to the last comment. Since we are McGill, and the civil law is a very important component of the McGill tradition, for many years in Canada, we've looked to the common law. The civil law has looked to the common law, and as others would say, the civil law was corrupted by the common law, right? I'll spare, Justice Gontier's various quotes, but I think this is the era, and I've said it in the context of cyber defamation, where the common law can look to the civil law for the twin pillars of flexibility and permanence, right? The civil law had to wrestle with the Industrial Revolution, and you look at quotes from the 1800s reminiscent of Socrates saying this generation, is terrible, not like the previous generation. The civil law had to find ways to come up with a principled approach, and that I think joins Claudia's argument about let's not throw it all out. Let's come up with a principle-based approach that is at a certain level of abstraction, and that includes, and I'll end on this, custom as well. At the beginning of the Industrial Revolution, the civil code had to sort of, the continental law had to sort of say, okay, will we ostracize all these merchants who were in the process of developing law, or will we integrate these customs? And this is why, I think in this very room too, in my first class here, we talked about the coutume as being a significant component of law. It's not just about le droit, it's also about customs. So perhaps the civil law has something to teach us in this era of instability and change about flexibility and permanence. So I leave that out to you, and we'll have
Thank
it
you.
come back to something.
Thank you, Karen, because in fact, interestingly, yesterday we had a meeting of the speakers and moderators, and this specific issue came up of how do you ensure the law keeping up with the technology. And one idea put forward was, well, when you have law that is principles-based rather than rules-based, you have clarity of goal, but flexibility of modality. That being said, it does have its limits. And if you will allow me just a moment to give you a very specific example of an issue where I had to deal with this tension, was when I was still leading the Office of the Privacy Commissioner of Canada. You may recall, if you were reading papers about those issues, that an Aboriginal activist called Cindy Blackstock made a complaint. I see some heads nodding. Cindy Blackstock, children activist for Aboriginal children, discovered that the government was actually following her on Facebook. Well, she had not friended the government of Canada, okay? Neither the Minister of Indian Affairs, and it was then called, nor the Department of Justice. And so she complained to our office. Both departments said, this is ridiculous. It was on Facebook. It's public information. And so we had to figure out, on the basis of a piece of legislation written in 1983, correct me if I'm wrong, but I don't think Mark Zuckerberg was born in 1983. I think he was born in 84, something, anyway, right? Or he was in diapers. What I mean is, you get the gist. The law simply was not built for Facebook. So what did we do? We went to the principles. The principles are, the government in Canada cannot collect personal information on Canadians, or on citizens, if not for justified purposes. The Charter says it. Right of protection from arbitrary search and seizure. How has it been interpreted? You need to have a demonstrated need, Government of Canada, for collecting the information, which is in fact the whole StatsCan issue right now. So we thought, did Indian and Northern Affairs and Justice need this personal information that they gleaned from her Facebook account? And the answer was, of course, no. Second question, was it personal information? Well, the Act defines personal information as information that relates to an identified or identifiable individual, including personal opinions. Ta-da! It was personal information. Third question was, yeah, but there's an exception that when the personal information has been made public by the author, it is no longer covered by privacy law. We said, okay, what does making publicly available mean? It means publishing writ large, putting it out there for anybody to see. Well, I'm sorry, Facebook, you have friends. Her settings were fairly broad because she was using her Facebook account for her activism. Admirable, by the way, editorial comment, but still. I assure you that I was not biased in her favor. Really applied the law. And the law led to the government had violated her right to privacy. On this 1983 law, we were capable of applying it to Facebook. And so why did we do that? We did that because, as Karen said, and as Claudia said, we grounded ourselves in the principles that define us as a society. Now, still, we have the General Data Protection Regulation, which is the first legislation that addresses automated decision-making. That means there was a legal gap. And in fact, in the discussion yesterday, Catherine piped up at some point and said, well, okay, this is really nice, this principles, clarity and flexibility of modalities, but, you know, like you can only stretch it so far. Indeed. And that is why AI is putting us in front of the very real issues that still do not have quite the perfect legal solution.